All right, so I want to welcome you all to the short attention span circus. In the blink of an eye, you'll miss a trick. In a nervous twist, you'll miss the entire act. Now, that was actually our circus motto, I guess you would say, in high school. So I've always been interested in juggling. It started when I was in grade school and not so great at baseball. Spent a lot of time on the bench. So I learned how to juggle a baseball and apparently not how to use PowerPoint. There we go. All right. So, we all do family law here. I think we all know that family law is much like a circus. We feature feats of skill and strength, amaze people with acts of awe and wonderment, and enthrall them with exciting illusions. You may have noticed my first illusion. I've already made 75% of this room disappear. So, we're going to keep up with those sort of things. In family law, we have to juggle a lot. We have to juggle clients. We have to juggle our staff. We have to juggle collecting money. We have to juggle the ping pong, the back and forth of what our client wants, what the other side is alleging, and what the judge wants, a lot of times, more importantly. And so, as we are all jugglers, thought it might be good to start off with what is juggling? Well, it's continuously tossing something into the air and hopefully catching it, usually a number of objects, and often for the entertainment of others. I think sometimes our clients just give us some hard facts or some difficult cases just so that we can entertain them with how we can deal with it. So that takes us to a juggler. What is a juggler? It's someone who skillfully balances several activities at once, which I know we all do. So, what kind of juggler are you? The juggler that doesn't really know what you're doing with the tools that you have? Or are you the juggler that just makes everyone seem so impressed with what you're doing? I'd like to think that we are the juggler who makes everyone feel so impressed with what we're doing. So today we're going to talk about the Form 14. As you know, the Form 14, I think we all feel like is pretty simple, right? You can be the type of attorney who juggles the Form 14 like juggling tennis balls. Tennis balls are the first thing that anybody who juggles learns how to juggle usually, unless they use scarves, and usually they're not really good at what they do. So you can be that type of juggler. You can start with the tennis balls. You can do the Form 14 and just sort of put the numbers in. Maybe many of you, like I, use Michael Cohen's program. Pretty straightforward, very easy. You don't really need to know a whole lot. You just need to know some numbers, plug them in. You get a number at the bottom, bingo, bango, you're done, right? I wasn't really content with juggling just the tennis balls. I wanted to move on to bigger and better and stranger things. They told me I couldn't light the torches in here because there's some issues with liability. But, when you're juggling torches, especially, pins are cool too, I guess. Torches are a little more fun because they have fire. But juggling the torches is a little more impressive. It's a little more difficult. The weight's a little difficult. You got to adjust. And you can do big fancy finishes and stuff like that. It's a lot of fun. So, do you want to be that kind of juggler with your Form 14? If so, I've got some tips for you. So, we've got line 11, the adjustment for the overnights. This is a big one. This has always been somewhat difficult, and this is an update alert. We recently had an update to the Form 14s, so this is one of those. We used to just have that sort of very simplified, 6% for this number of overnights, 10% for this number of overnights, 34% is the most if you've got 50-50, and then everything in between is sort of a crapshoot, right? Not very helpful. If any of you practice in St. Charles County, you know that some of the judges out there started doing their own sort of calculations and saying, well, this is what I'm going to do for each of these intermediary numbers. Thankfully, I think, we have decided to take that and use that now, and we have a very straightforward set schedule for all the number of overnights. All the different percentages, everywhere from 0% to 34%. So, there's a lot of questions with why the 34%. That's probably the number one question maybe after why don't I get to claim the tax dependency exemption, but why 34%? If I have them half the time, why don't I get a 50% credit, right? Well, that takes us to assumption 12. If you've never read the assumptions or the instructions or anything about the Form 14 and you just plug and play, I suggest you look through them. It's a thrilling read. That's not true. But it is very helpful, and a lot of those things I will be talking about today. So assumption 12. With respect to the adjustment by the portion, blah, 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 you guys can all read. And as you'll notice from this slide and other slides, assumption 12 is very long. So assumption 12 breaks down the expenses for the children, right? We have the variable expenditures. Those are things like food. Those are obviously going to change when the child is with the parent. You know, if the child's not with you, you're not paying for their food, usually, seems right. In their infinite wisdom, the writers of the Form 14 and the assumptions, they decided that these variable expenditures represent 38% of the basic child support amount. The duplicated fixed expenditures, which are those expenses that do not vary with the amount of time that a child spends with a parent, like housing costs, those represent about 30% of the basic child support amount. And then the non-duplicated fixed expenditures. These are the ones that don't vary with the amount of time a child spends with each parent, and according to the people who wrote the assumptions, are typically incurred by a parent whose household the child resides in a greater amount of time. Okay? Those represent 32% of your basic child support amount. Now, for all you math whizzes out there, if you take 100% minus 32%, that gets us to 68%. And what is half of 68%? 34%. And that's why we're limited to that 34%. All right? Everybody hates math, right? That's why we're all lawyers. So, if I want to explain to a client why they only get 34%, this is how I explain it to them. They get really bored really quickly and they don't ask me any more stupid questions. That's not true, but they still ask stupid questions. So, this is part of that assumption 12. As it is assumed that the payment of non-duplicated fixed expenditures does not vary even when an award of custody results in the child or children spending substantially equal time with both parents, the maximum adjustment is 34%. Now, it does go on to say, in appropriate circumstances, the adjustment may be up to 50%, especially when non-duplicated fixed expenditures are paid primarily by the parent obligated to pay support. Now, I have some problems with that because, well, if the parent primarily paying them is the one who's paying support, why don't they get more than half that percent? But I digress. So, the amount of the adjustment varies on overnights, okay? We all know that. So, some things that we look at. If there are no significant expenditures for the children, if that parent exercises visitation less than 36 overnights per year. And they say periods, but this is overnights. So that's another question you might get from your client. Well, I have them, you know, however many hours out of the week, and shouldn't I get a higher percentage? Well, we only count overnights. Again, don't ask me why, but those are the rules, and that's what we got to know when we need to explain these sort of things to our client and make the arguments to the judge. The Form 14 assumes that variable expenditures for the children, that the parent paying support will have variable expenditures for the children if that parent exercises visitation for 36 or more periods of the year, and then duplicated fixed expenditures for the children if that parent exercises visitation or custody for 110 or more overnight periods per year. So, the housing expense, I mean, that's the one that we're talking about with the duplicated fixed expenditures. The variable expenditures, that's just the food, right? And then we say, at least under the assumptions, that there are no significant non-duplicated fixed expenditures for the children for the parent paying support. All right? So, I'm not going to go through this whole part, but the highlighted part, the court, it says, when the court's deciding whether or not to use 50% for the visitation credit in lieu of the 34%, or some number in between the two, the court should consider the presence and amount of disparity between the incomes of the parties, giving more weight to those disparities that's less than 20%, as well as considering which parent is responsible for the majority of the non-duplicated fixed expenditures. And here's where it gets a little interesting, such as routine clothing costs, costs for extracurricular activities, school supplies, and any other similar non-duplicated fixed expenditures. All right, so when I look at this, all right, and we all know that the presumed child support amount is just that, it's a presumption, right? And that presumption is based on the assumptions that the writers of the Form 14 made when they come up with these presumed child support amounts. So, non-duplicated fixed expenditures, clothing costs, right? Do we ever have parents who say, all right, the person who's receiving support is going to be the only one who pays for clothes, and if the parent who is paying support buys any clothes, they can send a receipt to that other parent because they're the one that's responsible for clothing costs. Has anybody ever agreed to terms like that? I mean, if you have, great. Like, you're apparently an amazing lawyer and you can do some of the mind tricks that I can't. But that never happens. Extracurricular activities. We almost always divide those outside of the chart, right? Usually those are based on income percentages, so it's as if it were in the chart. But we always divide those outside of the chart. School supplies, that one, yeah, I can probably give you that one. I've had people try and put that in as a school expense or an extracurricular expense that's going to be divided by the parties. And I say, no. The assumption is, unless you want my client to be able to pay less in child support, the assumption is that that parent is paying for those school supplies, right? And it's your job to advocate your client's position and take those sort of positions based on the assumptions that this chart is looking at. And then other non-duplicated fixed expenditures. So, I mean, this can range from anything, but they're the type of expenses that, as it said previously, the expenses that do not vary with the amount of time that a parent spends with a child and is usually incurred by one parent. So we have some problems with these assumptions already, right? These are things that we need as practitioners to bring to the court's attention when they're saying, well, look, the chart is just the chart and it is what it is. Well, it is, but it also isn't when we're going and doing things that are different than what the chart assumes we're going to do. Okay? Well, for these visitation credits, what about college-age children, right? College-age children are really difficult because we don't know where the kid's going to school. You know, are they going to clown college? That's okay. Everybody's got to have a dream, right? Are they going to college in town? Are they going to college out of town? Is that parent going to have those non-duplicated fixed expenditures at their house when the child's there or when the child's not there? So these are all things that, that we can take into consideration. We can get a little creative sometimes in how we deal with child support and running a chart when a child is at college. We can look at these numbers and try and figure out ways to better advocate for our clients. In the assumptions, it says the fact that one or more children subject to the support order are over 18 and no overnight custody or visitation is ordered for the child, it does not preclude the application of the adjustment when circumstances would support an adjustment for periods of overnight spent with the obligated parent. So this is in cases where, and we do this, we don't really do this that often, and I think I've tried to incorporate it in my practice a little more. When I have children that are over 18, we're not required to include a parenting plan for them, right? I don't know if anybody was aware of that, if everybody was aware of that, but we're not required to enter a physical custody parenting plan for children over the age of 18. But even if we don't have that parenting plan, we still can include a visitation credit if that parent who's paying support is going to be having significant contact with that child, especially overnight contact, to where they're going to be incurring more of those expenses that the Form 14 would presume would be paid by the parent who, quote unquote, has more custody time, or the parent who's receiving support. Now with the line 11, we also have caveats. Caveats are a lot of fun. So, except as provided in the next paragraph, an adjustment on line 11 shall not be allowed unless the adjusted monthly gross income of the parent entitled to receive support exceeds the amount set forth in the table below for the appropriate number of children. Okay? So a lot of us have seen this one before, right? You don't get a credit if the parent who is receiving support doesn't earn enough money. And that makes sense, right? Because this person is going to need that extra money regardless of how much time they have with the child, because they don't have sufficient funds to help meet that child's need. And that makes sense. And I've had to explain that to my clients before. It's a hard conversation, but it's something that I think most of them can understand. That also, though, has its own caveat to it. Notwithstanding those amounts, an adjustment may be given if, one, the parent entitled to receive support is unemployed or underemployed because the expenses of that parent are paid in whole or in part by a person with whom that parent cohabits, okay? So this is always the fun one, right? These are modifications where you've got somebody who's remarried and they decided, you know what, now's a good time for me to be a stay-at-home parent. I don't have to work anymore. So often in that situation, we will want to just impute income to them, which may be more appropriate, but we may also want to include the visitation credit to sort of supplement that. If that person is making that decision to be underemployed or unemployed because they have sufficient assets by their new spouse, new boyfriend, girlfriend, parents, whoever is helping them out, that visitation credit may be appropriate in that circumstance, even though their income is below that threshold. The other caveat to the caveat is if the adjusted monthly gross income of the parent obligated to pay support less the presumed child support amount would be equal to or less than the amount set forth in that table. So it's sort of the reverse of the first caveat, right? If the person doesn't have enough money and they can't afford to have that visitation credit, but then the person paying support also doesn't have enough money to where they can't afford to not have that visitation credit, it may be appropriate for that visitation credit to be included, or some visitation credit. It may not be the whole amount. That's going to be case specific, right? Now, comments. There's also comments. So we've got directions, we've got instructions, we've got comments, we've got caveats, we've got presumptions, we've got assumptions. There's just so much fun reading in here. I thoroughly recommend you spend a good day with it. Maybe on the beach on weekend time, maybe not on weekend time. In any proceeding to establish a child support order or to modify the support payable under an existing order, the adjustment on line 11 may be rebutted if the parent obligated to pay support without fault of the parent entitled to receive support does not exercise the periods of overnight visitation or custody with the children who are subject to the proceeding awarded under any order or judgment, okay? So this is for the cases where you have an individual who was awarded a significant amount of time, but for whatever reason, they choose not to, their work doesn't allow them to do it, whatever it might be, they're not actually exercising all of the time that they're supposed to under that order. This is a rebuttal in a reduction of that support, or of that visitation credit. So if the parent entitled to receive the support isn't the reason why they're not exercising the time, okay? This doesn't apply if the parent who is supposed to be receiving support is withholding custody. And they say, well, he didn't actually exercise his time this year, so he shouldn't get that credit going forward. Well, that's because you were withholding. We're not going to hold that against him. And I'm going to say him a lot, one, because I represent guys mostly, but two, because guys are also mostly paying the support, right, usually. So it could go either way. This is not a gender-specific child support forum, I guess. Comment C also tells us that if that parent who's paying support does not incur significant expenditures as a result of the exercise of their custody, so if you've got somebody who's just a total hard case and they say, I'm not paying for anything other than what the child is using during my time, okay? It brings up a little question about the presumption that we talked about before with the clothing costs and how that's in the presumption, that's built into the presumption, but if they're not going to contribute anything to, sports, they're not going to contribute anything to school costs, they're not going to contribute anything to any of those other costs other than exactly what the child uses in their custody, it may be appropriate to reduce or remove that credit. Or if without fault of the parent entitled to receive support, exercises the periods of overnight visitation, but not all of the children, with some but not all of the children who are subject to the proceeding. So here's where you have those cases with maybe one child who's got a really difficult relationship with that parent. And it's not all of them. Or if you have a case where you have, and I had this one recently, I actually went to a couple of judges and they didn't really know how to deal with this, so we just kind of worked it out on our own. But where you have a case where maybe one child has a good enough relationship, and you say, okay, we're going to do, 5 out of 14 with that child. The other child absolutely hates the other parent. We're doing therapeutic supervised visitation with them because they just cannot handle a normal custody schedule. All right? Well, what number do we use? Because we have 2 kids. We're only running 1 chart. It doesn't make sense to run 2 charts because then you're going to actually increase the amount of support. We have 2 kids. One is going to work their way up to a 50-50 schedule, so maybe a 34%. The other one is going to have 0. What do we do? Well, in our case, we just averaged them, 0, 34, 17.5%. We used that number, and that worked out for everybody. It seemed like the logical thing to do. There's no actual instruction here to this comment to say what you should do in that circumstance. It just says that that number can be rebutted based on some of these new situations. All right. So, line C. Or I'm sorry, line 11, which is my favorite line. Any questions about line 11, overnight visits? Yes.
Well, do you think on those comments you were just going over, what about the reverse? If it's the parent paying support, but, so say it's dad paying support, the mom relocates, he allows her to relocate, but now he can't exercise maybe his during the week visitation because of where he's agreeing she can relocate to, because otherwise the kids would have to get up too early. Do you think he has that, even though he's not the one entitled to support in those comments, can come back and say, well, I should still get a higher credit because I'm allowing her to relocate?
Okay, so the question was about if a parent's relocating. Let's say the parent who's receiving support is relocating, and so the parent who's paying support now can't exercise their time. One, you could say that that is the result of the parent who's receiving support. And so that would fall under the first one that talked about if it is due to no, let's see, what was it? Without fault of the parent entitled to receive support. You could say that's the fault of the parent entitled to receive support, but if that person consented to them relocating, okay, that could be another, you could say it's not their fault, you consented to it. So then we're talking about a modification at that point, because until it's modified, right, they still pay the same support number. So that means the same visitation credit is still in place. Once we get to the modification stage, then it's a question of, is it appropriate to have that person paying more in support, even though they would still like to exercise as much time as they had under the previous schedule, but it's no longer feasible because they're now an out-of-town parent. We have to do an out-of-town parenting plan. Obviously, it's going to be up to your judge. They're going to make, you're going to make some equitable arguments that that's not going, it's not my client's fault that he can't exercise the time he wants to exercise. On the flip side, the parent receiving support is going to say, well, look, I have more expenses now, right? And so those expenses, whether you want me to have them or not, whether you would want to have more of a share of them or not, I have those expenses. That's the reality. And so we need to find an appropriate support schedule there. I think what you would try and do is maximize the amount of time that your parent who's paying support has so that they can get that appropriate credit. So that may be, and this is like most out-of-town parenting plans, most of the time during the summer, most of the time during school holidays. If that parent is able to go up there, go to wherever the out-of-town parent is for some visitation time on a weekend or something like that, build that into your plan. Also, one thing would be to build in maybe the travel costs. Because if that parent is moving and that's forcing your client to incur more travel costs, then I think there should be, if not incorporating it into the Form 14, I would try to incorporate that into some other language in the support part of the parenting plan to say that the parent who moved is responsible for the travel costs for the child, or at least a larger percentage of the travel costs for the child, because it was their decision to move. That's where I would go on that, whether that be in the chart or out of the chart. Any other questions on line 11? Yes.
Okay, what about the scenario when children are away at college?
Okay.
So let's say, what kind of a line 11 credit do you give when the child's away at college, all their food costs are paid? They only come home, let's say, Christmas or a week or two, Thanksgiving for a few days, and they're gone all summer. Like they stay at their school or go somewhere else for the summer.
So the question was, what do you do with the visitation credit on a college student where they're gone all year, their food costs are paid through a food plan, they don't come home during the summer, they're a child that wants to stay at school during the summer and maybe work during the summer or do summer classes, whatever it may be. How do you adjust for that? I can tell you that if you are in a certain division in St. Louis County that I was in this past week, that will not matter. Ultimately, it's going to be up to the judge. Now, what kind of arguments can we make? Because, of course, I'm making these arguments as I have done my research for this presentation, and so I'm thinking, yes, I've got great arguments here, Judge. And I'm like, Judge, the assumption says, and I read out the assumption, and the judge says, well, that's great, Will. That's awesome. Mom's still got to keep the lights on at the house because there's going to be that time when the child's going to come home. Okay, give my guy a 50% credit, Judge. That'll give her enough money to keep the lights on. We'll be fine. Well, all right. Does that mean that Dad is now going to be paying all of those, when the child's food card runs out in November and he calls up and says, hey, I need some more money so that I can eat this weekend, who's he calling? Is it Mom or is it Dad? Well, Judge, honestly, I'm going to guess it's going to be my client. It's probably going to be Dad. Okay, are we going to put that in the order? Well, he'd probably be happier if he was paying it to the child than paying it to Mom, but that's neither here nor there. Who's he going to call for tickets for the basketball game? All those sort of things. So while I don't agree with all those arguments, it starts to get a little more dicey. You make those arguments, and you've got to be prepared to back them up. So you can go back to the assumptions and say, well, look, Judge, 38% is based on these variable expenditures, right? So 38%, if there's no visitation credit, 38% of what Mom's going to be paying, what she's going to need for this child, is based on those variable expenditures. And that's based on the child being in her home. So if the child's not in her home, 38% of those costs that are under that presumed child support number don't exist for her, right? Now, there's counter arguments, and we could spend probably all day on just line 11 because it's a very, we'll say, litigated area of the Form 14. But that's sort of where you can go with your arguments, is to bring the numbers up. And it gets you into a bit of a sticky situation because a lot of us as lawyers became lawyers because we didn't have to do a lot of math. We're not big fans of math. I love math. My wife's an actuary, so that's probably why I like doing this stuff. But that's where I would go with it, is say, well, look, Judge, at a minimum, that 38%, it doesn't exist because the child's at school. Now, how are we splitting that meal plan? Is Mom responsible for a portion of that meal plan? Is that portion supposed to be coming out of child support, or is that just supposed to come out of her normal income? Those are going to be the questions that you're going to have to deal with and kind of determine which way you want to go with that. All right. Yes?
What's the rationale or the policy with the exception in Rule 11 that says if you have an unemployed parent, unemployed person that's receiving support who is cohabitating with someone who's paying all of their expenses, what's the rationale or policy for visitation credit under those circumstances? Because I struggle to see what will convince a judge to, I guess, essentially agree to less support for the unemployed parent who's receiving support.
Sure. So the question was about the exception where if they're under a certain level of income that you can't use a visitation credit, right? And there's the exception that if that person's expenses are being paid by either a new spouse or someone who they're cohabitating with, what's the rationale for that? And how do you make that argument to the judge? So the first place I would go with it is imputing income. If somebody is capable of working, if they're not disabled, they have education, they have a work history especially, Impute go for imputing income. I think that's your first thing. Judge, look, she can work. If we have to get an expert in here, a vocational expert, to say these are the jobs that are available for that person, we're going to ask that vocational expert's cost be taxed as cost because this person knows that they're able to work. But they should be earning a certain level of income, and it's going to exceed the threshold that we're talking about here. All right. If the judge doesn't want to impute them with income, and they just say, all right, well, I'm going to use their income number because that's really all they're making. I don't really like it, but that's, judges make the decision. Then you go to the credit, and you say, well, look, Judge, it's appropriate in this circumstance for him to have the credit. And you go to the instructions of the Form 14. Say, look, Judge, if her expenses are being paid by this cohabiter, which they are, and we can prove that, she got remarried, this guy makes $250,000 a year, she became a stay-at-home mom right after they got married. She was working all the way up until that point, all right? It's appropriate. We're not taking money out of mom's pocket. We're not, putting the kids in a more detrimental state by not giving mom as much money because they have the resources as that new unit to meet those kids' needs. And the expenses that would normally be paid out of mom's income are being paid by somebody else. So she has more money available, whether it be child support or whether it be her minimal income. She has more money available from that to meet the child's needs as opposed to paying the bills in the house and doing all the other things that she wants to do.
On an underemployed situation, do the judge, do they do it case by case? Do they typically impute minimum wage? Do they typically?
So it's case by case. It depends on what the parents' my experience at least has been. It depends on what the parents' work history experience has been, and also what their education is. If you've got, basically parties who got married out of high school, mom never had a job, doesn't have education past high school, never worked, she was just a stay-at-home mom the whole time, you might be able to impute minimum wage. You're probably going to be looking at that. We'll talk about how childcare might come into play on that a little bit later. But typically minimum wage is that. If you talk to, I think it's probably well known, but if you talk to Judge Essner, he, in my experience, has no problem imputing anybody at minimum wage without an expert. He says you can, pretty much anybody. If you are not disabled, if you are employable, of employment age, you could probably go out and get a job at minimum wage, and I can impute you at minimum wage. Like I said, we'll talk about how childcare comes into that later on and why you might not actually want to do that. In order to impute somebody at higher than minimum wage, he wants you to have an expert. You have to have an expert.
Regardless.
Right. You can look at an average of previous income. That's okay. That's different than imputing because there's instructions in here that talk about averaging last however many years of income. But if you want to impute somebody and say they're not working up to the level that they should be able to, then you're going to need a vocational expert.
I've got a guy that's working 2 days a week and performing as a musician at night. And he's blasted all over Facebook that he's performing at this location, that location. And he's claiming to make $6,000 a year.
I like his style. No, that's terrible.
Wait a minute, he's got 3 mentally handicapped kids.
Sounds like it's going to be a tough case.
Does the new Form 14 provide any more clarity on including other children who reside in the home when a counterpart is filed?
Yes, and that's going to come up a little. Well, it doesn't provide, I won't say it necessarily provides any more clarity, but that's going to be coming up here a little bit about other children. All right. We're going to move on so that we do get out of here by 5. So line 5, the basic child support amount. All right. It was my understanding there would be no math, right? This is one of those things that us as attorneys, we look at this and we're like, oh my gosh, okay, what are we doing here? On the update, for low-income cases, all right, how many of you have seen this part of the update? How many of you actually understand this part of the update? Shocked that nobody raised their hand, whether or not you understand. All right. For low-income cases, when the parent paying support's monthly income falls within this fun shaded area on the presumed chart, we're going to do a little bit of magic, okay? It's another good part of the circus. First, we're going to complete the calculation as normal. Okay, we're just going to run a normal chart, see what it comes out to. Okay, in this one, you have your example of the Pitt versus Lee family in your packets. You'll see the Form 14 here in a little bit. So we calculate a normal chart first. Then, we're going to complete that calculation using only the basic child support amount from the obligor's gross monthly income from line 3, with line 9 consisting of the obligor paying 100% of that amount, plus the obligor's percentage from line 4 and line 7 of the additional child rearing costs. All right? We're only getting started. Then, line 4 and 11 will remain the same as the original calculation, and the line 11 overnight percentage credit remains the same in both calculations. All right. So, are we all confused enough? The lower of the two calculations shall be the parent paying support's basic child support obligation. All right. So I think we've done enough mental gymnastics. And this guy just says it all. So let's look at the concrete example. All right, you might not be able to see this very well from where you're sitting, so just look in your packets. It's probably going to be the last page, if not close to the last page. It'll be right behind my packet of slides. So, when we're looking at this chart, this is the first chart, right? We've got 4 children, okay? We've got relatively low incomes. Unlike their namesakes, the Pitt-Lee family did not have a ton of money. This chart just run with normal credits, okay? We've got 60, I think it's 67, 68% to 20%, something like that. Variation here. And the presumed amount for the first chart with a 10% credit, because if we did the reduction, it would fall underneath that lower number. So we've still got that 10% credit in play, and it comes out to $418 a month. All right, now if we look at the second chart, you'll see we get rid of the parent receiving support's income, okay? We're getting rid of their income, and we just find out the presumed child support amount for just the parent paying support's number. So that's $371, okay? For some unknown reason, these people are using daycare. I guess dad makes enough that it makes sense for him to have daycare during his time. So he's got $200 a month in daycare that he pays. So he's still going to get that $200 credit when we go down to line 10. The presumed basic support number of 371 plus dad's percentage, which was, I believe, like 68.7%, something like that, of the $200 in the additional child rearing costs. It's $137. So that gives us our line 9 number, minus the credit that he gets for the additional child rearing costs that he pays of $200, minus the 10% visitation credit, which is 10% of that original line 5 number from the first chart, gets us to the presumed child support amount of $226 a month. So because that $226 is lower than the $418, his support number would be $226. All right. On that fun issue, questions everywhere. Does anybody have any questions about how we do or why we do that? The why is going to be a little harder for me to answer, but how we do that calculation and we get to those numbers. It's a lot of math. It's not a lot of fun, but I promise you it does work out. Also, a little bit of a plug, if you use Michael's program, it does it for you. So no problems there. And it does work. I've verified the math.
Do you file both of those with the judgment?
So you would only need to file the one with the lower number. because that would be the one that actually shows the chart that you used. If you want to file both, you can, in order just to explain to the court why you're using that lower number. And it may be instructive for a modification later on. It may help you out, may help your client out later on, so you may want to do that.
You had to go back over to the first one, get the presumed child support, figure the percentage on this one.
Correct.
It would make sense.
Right. As long as you have the correct chart in there, you only need the one chart. But I think for future modifications and maybe explanation to your client, it may be wiser to include both so that you can explain from that first chart why you're using the numbers in the second chart. All right. Talking about this before. Taxes, right? This is one that is probably the one I get the most questions about from my client. If I'm the one that's paying support, if I'm the one that is providing for this child's financial needs, why do I not get to claim the child on taxes, right? The short answer is it's a presumption, right? It's a presumption in the chart. It's presumed that the parent receiving support is going to receive the child dependency exemption, and that's the way it is. If we didn't have that presumption, this is what I tell them, if we didn't have the presumption, your basic child support number would just be a little bit higher, okay? And we can do that. You know, Judge Essner had the case that went up on appeal. It was found that he was correct in what he did, where he took that presumed child support chart, said, I'm going to find that this is unjust and inappropriate, which is what you need to do anytime that you allow the parent who is paying support to claim even one of the children as a tax dependency exemption. You need to find the child support chart unjust and inappropriate, even if you're using the same child support chart. Because it's a presumption, if you're going against one of those presumptions, that means that the original child support chart is unjust and inappropriate. Okay? It's something not a lot of people do. Most people don't. And there's very few judgments that I've seen that have done it the way that it should be done, because you're going against a presumption of the chart and saying, I only need X amount, even though I'm giving up that dependency credit, okay? The other part about taxes, this is one that doesn't come up often, but it does come up. Non-taxable income and significant employment-related benefits may be converted in appropriate circumstances, emphasis added, to gross income through applicable federal and state income tax tables. All right, so what does this mean? If you have a client who is receiving income that is not taxed, okay, that can be grossed up to a gross number using those federal and state income tax tables. The assumption is that, and I don't have this on the slide, or I take that back, I do have this on the slide. Look at me actually being prepared. Assumption number 3 says all parental income is treated as earned income subject to federal and state withholding and FICA taxes. All right? So it's just, when they created this chart, it was presumed that those gross numbers were going to be earned income subject to these withholdings. So the actual money that's available from that was taken into consideration. The schedule of basic child support obligations is prepared by converting net income to gross income using withholding tables for a single person. Okay, so if you do need to gross up income, you have to look at the withholding tables for a single person. Even if that person has remarried, whatever it might be, those are the tables that you use when you're looking to gross up that non-taxable income.
Would an example of this be mileage?
So mileage is one of those that falls into a bit of a gray area, because part of mileage, because mileage is really reimbursement of an expense, in theory, right? Ish, right? It's going to be a little more than your gas expense, but it's also taking into consideration wear and tear on your vehicle, all of those sort of things. So I would say, and to be honest with you, I don't know what the court would say, but I would say, if you brought that argument to me, I would say no, that doesn't count, because it is reimbursement. If you're going to, then you have to, essentially you'd have to do all the math of saying, well, here's how much he actually spent in gas, or how many miles that he spent. here's a number. You'd have to get an expert to say, here's how much effect that mileage is going to have on this vehicle, and the future expenses for that vehicle's care. We're going to have to reduce the cost of gas. We're going to have to find out the cost of gas at the time that person actually drove the vehicle, or the time they filled up, because it could have changed by 40 cents a gallon between 2 days. The mileage one's going to be a little tougher. This is more for military. There's some military benefits that are not taxable. That's the one where I've seen it brought up before. Disability can fall under this also. Now, in the instructions for line 1, it talks about which disability is considered income and which disability isn't considered income. What is it? SSD is considered gross income.
Speaking of military disability.
Oh, military disability, yes, yeah.
Some of them get like $1,200 a month.
Right, and that, under using these assumptions and using what line 1 defines as income, those can be grossed up in an appropriate circumstance. So that's going to be the flip side of the argument is this an appropriate circumstance? If their disability income is based on a complete disability to work, okay, because we've all had military clients who are receiving disability, they're also working a second job, or they're, whatever else it might be, other sources of income. In that situation, it might be more appropriate to gross up the income. If it's based on complete disability, it might not be appropriate to gross up that income, because they are limited in the amount of income that they can receive to just that disability income. So that's where it's going to become, there's a little bit of flexibility for the court there, and that's where you have to make that argument to the judge of saying, well, look, judge, although it's allowed, it shouldn't happen in this situation, and here's why. Okay. And then finally, assumption 6 also says conversion of net income to gross income assumes one exemption and the standard deduction. So if you are doing this, if you plan on doing this, definitely look at the assumptions, make sure that you are doing it right, that you're using the right numbers, and if somebody is trying to do this to you, make sure that they're using the right numbers and that you back check what they're trying to sell you. All right, so here's kind of where we're getting to the question on what do we do with other children, okay? Adjustment to gross income paid for other ordered child support being paid, maintenance being paid, and other children primarily residing with a parent, okay? Also known as the sword and the shield, right? I wanted to bring up, in my circus that I was in high school, we had a sword box trick, right? And I wanted to bring that up and use the sword box here. Again, liability, they said we don't want any injuries. So, I think I got to give a little bit of trouble to Sam because he used my movie without me. Leonidas and I, we go way back. I think I'm going to change my picture on all these things to this one because it's a little more intimidating, right? Fear the beard. All right. So the sword and the shield, what do we do? Line 2A direction says, an adjustment is appropriate in a proceeding to establish a child support order or to modify the support payable under an existing order. However, the adjustment available to the moving parent, all right, and that's key, in an action to increase or decrease the support payable under an existing order shall be the lesser of the adjustment to which that parent was entitled for the particular child on line 2A or 2C when the existing order was entered, or the adjustment to which that parent is entitled for the particular child on line 2A as a result of an order in another action entered after the existing order. All right, so what does this mean? When we're talking about the sword and the shield, we're saying you can use this as a shield but not a sword. So if you're the moving parent, if you represent the moving parent, and your parent has, let's say, a new child since the last order, and you say, I want to include that child as a child in the chart so that I reduce my gross income, okay? You cannot do that. You cannot use it as a sword to try and reduce your child support or increase the other person's child support if you are the moving parent, okay? Alternatively, if your child, let's say you were paying child support, okay, that's the second part. Line 2A, if you're paying child support according to another order and you got a modification in that order, this is going to come into strategy about which one you want to modify first. If you modify your other child support order, and you have a lower child support there, then when you go to modify in this current case, you can only use that new child support number. You can't use that older, higher child support number because you're no longer paying that, and you're the moving parent, right? So you can't use it as a sword. You can't use it to try and reduce your income, or you can't use it to try and reduce your income, whether you're trying to use that to increase the other person's support or reduce your own support. Okay? That goes on. In any action to decrease child support, a parent obligated to pay support shall not be entitled to a line 2C credit for children born or adopted to the parent obligated to pay support after the entry of the current order. However, the parent obligated to pay support will be allowed a line 2C credit for children that have remained primarily residing with the parent obligated to pay support from prior to the existing order. Okay? So if you had a parent or a child prior to the existing order, and they were included in that first order, then you can use that child in your chart because you used it the first go around. Okay? Seems to make sense. If you already had used the child, you can continue to use the child. You don't change it because you're still using that same number. Does that make sense? Then finally, in any action to increase child support, a parent obligated to pay support shall be entitled to a line 2C credit for children born or adopted by the parent obligated to pay support after the entry of the current order. However, the use of the credit alone cannot act to reduce the current support amount in the action in question. So I think this, to some extent, goes to the question that you had previously, Curran, of what do we do if you are the non-moving parent and you have a child in your home that wasn't in your home prior to the last order, right? All right. So you are allowed to use that child as a shield to prevent the other person from increasing your support obligation. So if they want to say, well, look, Judge, if we run this chart again and we're using all the same numbers as last time, his child support goes up by 20%. So there's a presumption that substantial and continuing change in circumstances, we want to move forward. We want to modify, he should be paying more. You can include that new child in the chart to sort of shield yourself from that increase. However, you can't use that child. So let's say you run that new chart with the new child, and by some stroke of luck, it actually decreases your child support now. Well, that doesn't matter. The only thing it matters for is to say you can't increase my child support. You can't use it to say, well, now we should decrease my child support. Does that make sense? Does that answer your question at all?
So in that situation, you can use the old child support number if one way is allowed, the other way is allowed?
Right. So if there hasn't been a change in circumstances, you still use the old child support number, right? Because there's no grounds for modification. If you can show that there's been a change in circumstances, let's say you run a third chart that uses your guy's income and uses the old number of children for your credits, and there is a change, well, then you can have a modification there. But you can't have a modification to decrease it just because of a new child. They can only be used as the shield, not the sword, to try and reduce your support amount. Does that answer your question? Sure. All right. If you have more, we can talk about it more after, because we do want to get you guys out of here by 5. All right. Work-related child care costs. All right. So this is a really long section that just kind of talks about everything. Basically, what we're looking at here is the court's going to look at whether the parent who's entitled to receive support remains obligated to pay his or her child care provider during the periods of visitation of the other parent. If so, the court's going to look at whether or not it's reasonable for that parent obligated to pay support to use the same child care provider or use a different child care provider. So this is a situation where you've got a parent who's using a child care provider that charges you by the week, right? They don't charge you by the day, they charge you by the week, or they charge you by the month because you have a week on, week off schedule. If the parent who's paying support, if it's reasonable for them to use that same child care provider as the parent who's receiving support, the court has the discretion under this comment B to say, you know what, I'm not going to give you a credit for this other childcare that you want to send your child to, because mom still has to pay all of that daycare cost, regardless of whether the child's going to this different one that you want them to go to, or they're going to the same one that mom sends the child to. Okay? So that's really a conversation you need to have with your client to say, look, why are we going to two different daycares? Okay? It might make sense if they live far enough apart from each other, the children are young enough and they're not in school, and you've got a custody schedule that, allows that both parents need to use daycare, but it doesn't make sense for them to use the same daycare. Okay, you might have child care credits for both parents. But if they're living close to each other, if it doesn't make sense for them to be using two different daycares, or more accurately, if it does make sense for them to be using one daycare provider, then the court may tell your client, I'm not going to give you an extra credit because you're going out and spending extra money just because you feel like it. Okay, so you've got a little bit of a problem there that you need to address with your client early on. All right, uninsured extraordinary medical costs. All right, these are oh so much fun. Uninsured extraordinary medical costs are reasonable and necessary medical and dental expenses as defined by Internal Revenue Code, incurred for the children who are the subject of the proceeding to the extent that the uninsured portion of such expense, including any deductibles and co-payments, exceeds $250 per year per child. All right, so a couple things to unpack on this. First of all, if you've ever wondered why in the forms that St. Louis County has, it says that the parent receiving support will be responsible for the first $250 per year per child, this is where that comes from, okay? Because the reasonable and necessary, the uninsured extraordinary medical costs, that extra in the extraordinary comes from being beyond $250 per year per child. Apparently there's an assumption that every child will probably spend at least $250 a year on medical costs. Hopefully that is not the case for all of you, and as a new parent, hopefully that is not a case for me, but I can tell you it already has been. So that's the first part of uninsured medical costs. All right, so if you are crafting a parenting plan, make sure that it still has this language in there. And when you're sending out a settlement proposal, make sure that it still has this language in there. Because if you send me a settlement proposal that says we're going to divide extraordinary medical costs 50-50, and you don't put anything about this $250, I'm going to be really upset if you've got that $250 in the language in the judgment. Okay. Also, we use this often when we exchange those, or when we change the income tax exemption, right? Well, I'll agree to give you one of the children, we'll do every other year with the child if you waive the first $250 per year per child. Okay, great. It's a great area where you can be creative to try and reach a resolution that will be a little more favorable for your client, whichever way your client would prefer. A lot of times the tax dependency exemption is going to be a little more than $250, but depends on what your client makes. So definitely something to look at. Yes?
The biggest argument I always see with clients in particular medical costs is braces on the kids.
Braces, yes. Braces are great because in the form, it talks about, or at least in the form in St. Louis County, it talks about not being cosmetic, right? That we're going to split these costs, but those costs don't include cosmetic medical costs. So there's a question, are those braces needed? Well, I can tell you if you go to Judge Bourbonis, he's going to tell you every kid's entitled to have braces. I made the argument to him. He didn't really like my argument. We'll just leave it at that. And he told me this kid's getting braces and my guy's on the hook for half the cost. Depends on your judge, right? I mean, I think you can make a solid argument that not every kid needs braces. That for some it is purely a cosmetic thing. Now, whether or not your judge agrees with that, that's another story. I think it's probably one of those things that's going to fall within judicial discretion, so it's not really something that I would look to appeal on. But I would certainly make the argument that, look, no, I mean, especially if it's not medically necessary. Like if a child has just a painful set of teeth that's going on, yeah, they need braces. Right? It's something that is harming this child. They're medically necessary. But if it is purely cosmetic and they're just like, oh, we need to tweak it a little bit. Like, I'm not talking like a big snaggletooth sitting way out, but we just tweak it a little bit and it'll be perfect so that, Johnny can have his career in the film industry. Oh, good luck to you, Johnny, but I'm not paying for it until the judge tells me I have to, and then, of course, I will follow whatever orders the judge requires me to. The other part on this section that I've run into, I guess, recently is be aware of specific language that you're putting in your parenting plan. I have an order that came out of California, and it referenced California statute. And in California statute, it talks about you have to provide the receipt to the parent receiving support, but within a reasonable time, but no later than 30 days. And then the person has a responsibility to pay it within 30 days after they receive receipt of the medical expense. Now, to me, that makes sense. We put a lot of that language in our own parenting plans, but it's not required to be in there for us. It's not in our statute. It doesn't say that you have to do that. So be very careful about the specific language that you're putting in there, or that the specific language that is in your client's parenting plan, so that you can advise them, okay, yes, you are responsible for these particular expenses. No, you're not responsible for these because they didn't pay them, or they didn't pay them, but they didn't provide you with the receipts in time, so you're not technically responsible for them. Maybe in front of this judge, you might want to consider paying them anyway, just because this judge is going to look at you a little sideways if you don't pay them. But under the judgment, here's what you have, and this goes back to giving your clients options. Here's your requirement. Here's what might be a good idea to do, but again, here's what you have to do, and then they can make that decision, and then it's out of your hands at that point. All right. So, any other questions about uninsured extraordinary expenses? Bueller. All right. And that's how it's done. All right. Yeah. Oh, we have a couple questions. Sorry. Go ahead. I haven't heard it. So the question was about the new federal tax guidelines and whether or not it's being considered, how that affects the presumptions or the basic child support amount numbers and all the calculations that have previously been done. I haven't heard anything coming down the pipe about whether they're going to make adjustments to those presumed child support numbers, but I think that's definitely something for us as practitioners to be aware of. Thank you. All right, and thank you all.